Okay, looks like we've got all the parties connected here. We'll go on the record. This is Cotton versus Cotton, case number 2319201. If I could have counsel put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Jennifer Deuce-McQuay on behalf of Taylor Cotton, who is present with me in my office.
Good morning, Your Honor. Katie Komorowski on behalf of the defendant, Ty Cotton, who is present with me in my office.
Okay, we've got a number of matters set for hearing in this case today. The first one I'd like to address is the objections to the proposed order arising out of our prior hearing back on November 4th. I did have a chance to review the proposed order submitted by both sides. Ms. Komorowski submitted her order. It was Ms. Dukes-McCoy that objected to that, and she submitted an alternate order. I also had a chance to review the video of the November 4th proceeding, and looking at the two orders and in light of the record that was made, the court finds that the order submitted by the plaintiff, Ms. Dukes-McCoy, more closely comports with the court's ruling, and so the court is going to enter the order as submitted by Ms. Dukes-McCoy. So that addresses the objection and the issue with regard to the order arising out of the November 4th hearing. The next matter that we have is there was a hearing before the referee, I believe on November 13th. On November 14th, the referee issued a recommended order, which Ms. Komorowski filed a timely objection to. And so we need to get that set for hearing. Ms. Komorowski, can you tell me, I'm going to be reviewing it, but I did not have a chance to review yet the transcript from the referee hearing. Can you tell me how long that hearing was?
Yes, Your Honor. The hearing lasted, it was at least half a day. It started after 1 o'clock and we went after 5.
Okay.
I believe that the plaintiff, she had mentioned at the beginning of that hearing that she had other people she wanted to call and there wasn't enough time.
Okay. So just so both counsel are aware, typically the way that the court addresses de novo hearings on objections is that the court limits the record to either new evidence that has arisen since the referee hearing, or witnesses that there was not enough time to be heard at the referee's hearing. I do not have the parties, present the same evidence that was presented at the referee hearing. I review the record and I take that into account along with the exhibits that were entered. So it's really more of a supplementation of the referee's record. So in terms of, with that in mind, Ms. Komorowski, how much time do you think we would need for the hearing before this court?
Your Honor, with that in mind, I think another half-day hearing would work.
Okay. Ms. Dukes-McCoy?
I would concur, Your Honor.
Okay. Do either of you need any particular period of time to be ready for that hearing, or do you just want the court to schedule it at the next available date? Ms. Komorowski?
I would like some time to get ready for that hearing, Your Honor. If we could have, at least 30 days to be ready before the hearing's set.
Okay. Ms. Dukes-McCoy?
I don't have any objection to that, Your Honor. I'm guessing the court can't schedule something that quickly anyway.
Okay. So we'll set this for a half-day hearing at the court's next available date, which likely, Ms. Komorowski, it's likely going to be in the 30 to 60-day range, I believe. So we'll set it for a half-a-day hearing. And again, counsel is directed to follow what I've indicated, which is limit their proofs to additional evidence that's arisen since the referee hearing and any witnesses that there was not time to testify to. Okay, in terms of scheduling on the objection to the recommended order, Ms. Komorowski, anything else that we need to address from your standpoint?
Not in terms of scheduling for that, no, Your Honor.
Okay, Ms. Dukes McCoy?
No, Your Honor, thank you.
Okay, and then we have Ms. Komorowski, your motion to disqualify the referee. I did have a chance to review your motion as well as Ms. Dukes McCoy's response to that. Ms. Komorowski, any oral argument you wanted to present today on that?
Yes, Your Honor. Typically, I would hesitate to file that kind of a motion because it's pretty, a serious allegation. However, in the parenting time that was subsequent to the November 13th hearing, the minor child in this case spoke with his father and indicated that the referee's son is in his same grade, attends the same school. He's very good friends with him, has met the referee outside of school. And in the conversation that my client had with his son implied that he felt that he had this relationship with the referee that would have had an impact on the case. The child asked about child support during that parenting time, how much money is his mother going to get, and all this type of questioning to his father that made his father feel uncomfortable about answering and discussing with the child. So we filed this motion for disqualification based on the facts that the child had presented to the defendant during his parenting time and, made the defendant feel as though the referee may have issued a prejudicial determination against him in that hearing.
All right, thank you. Ms. Dukes McCoy?
Thank you, Your Honor. As we stated in our response to the motion, counsel's statements are not evidence. They're reliant on hearsay statements of the child. The motion was not supported by an affidavit as required by the court rule under which the motion was filed, MCR 2.003. So it's procedurally improper. Further, we do not feel that there was any bias shown. There is a very heavy burden on the party claiming bias or claiming a problem with the fact finder to show that there is that bias, and that hasn't been met. Again, we don't even have an affidavit in support of that. A verified pleading is not the same as an affidavit. These statements are inadmissible, so they're not something that can be used essentially to support that anyway. So we feel that the motion is improper and that it should be denied.
Thank you. Ms. Komorowski, anything in response?
Well, I understand that Ms. Dukes McCoy is making a differentiation between a verified motion and an affidavit. However, in either event, my client did verify that this was his statements that he was making to the court, regardless of whether or not a notary verified it or not. Under the Michigan rules, an e-signature is a valid signature to be had to support a motion for, a verified motion. So that would be my response to that.
Okay.
As far as the hearsay goes, the child is not a party to the case necessarily. And so, I think it would be improper to have the child make a affidavit statement about this to the court. Certainly the court could have a in-camera review with the child to ask him about it if it was needed.
All right. I found this to be an interesting motion from the standpoint that, at least in the 12 years that I've been on the bench, I've not seen a motion to disqualify a quasi-judicial officer like a referee. And so I did some research. I know both attorneys did as well. And neither of you cited to any authority, really as to how a referee should be treated. And I couldn't find anything either really that directly applied to request to disqualify a referee, there is some case law regarding other quasi-judicial officers like administrative law judges, different boards with certain authority over public matters and so forth. And one of the parallels that I found is generally with quasi-judicial officers, they are treated for purposes of things like immunity, the same as a judge is treated. In terms of ethical standards, they apply to those officers just as they would to a judge. So while there isn't any direct authority saying that the court is to follow the same court rule and the same standards to disqualify a referee as it would a judge under 2.003, it certainly, to me, makes sense that if a quasi-judicial officer like that is treated as a judge for all those other reasons, there's no reason why they would be treated any differently for purposes of disqualification. So I say all that to say that I do think that 2.003 is the correct court rule to analyze this under. And so looking at the provisions of 2.003, I think we do have an issue here procedurally. It's not the same one, although I think Ms. Dukes-McCoy does raise a good point regarding the affidavit issue. But I think there's a bigger procedural issue here, because if the court is going to treat the referee as a judge for purposes of disqualification and follow 2.003, under 2.003 D3A, court will state that the challenged judge should rule on the motion first. And so that leads me to find that this should be brought before the referee, and the referee needs to make a decision about disqualification. Because number one, the court rule says it. Number two, it makes sense that the challenge judge should decide motions like this, particularly where there's an allegation of, the appearance of impropriety or personal knowledge of disputed facts, which are some of the grounds that were listed by Ms. Komorowski. And that's because the challenge judge knows what those relationships are. I have no idea what Mr. Legal's connection to this case is or isn't. Just as when I get motions to disqualify me based on relationships that my family members have with potential people involved in the case, I know what those relationships are, and I can state for the record whether I believe there are grounds for disqualification or not, and I can describe for the record, make a record as to what those relationships are. I can't do that on behalf of the referee in this case. So for those reasons, it also makes sense that the court rule provides that the challenged judge is the one to hear the motion first. Then that judge can either grant the motion, in which case it's a non-issue and everybody goes forward unless the other side wants to appeal that. But if the challenged judge then denies the motion, then it goes to the chief judge, which in this case would be Judge Hunter. And then Judge Hunter has a record. Mr. Referee Legal will put on the record why he thinks he shouldn't be disqualified, and it will address those relationships. And then Judge Hunter can review that upon request of the party pursuant to court rule and decide whether he thinks that those relationships should disqualify Referee Legal. So the court finds that it should follow that court rule. There's no reason if we are going to treat the referee as a judge in this case for purposes of disqualification, there's no reason not to apply that rule to the referee just as we would to any other judge. So the court is going to deny the motion on procedural grounds, not on its merits. To the extent, Ms. Komorowski, that you want to pursue disqualification of the referee, then that would be a motion that would need to be filed before the referee. If Referee Legal grants that motion, then all future hearings would be conducted before me as the presiding judge. If Referee Legal denies that motion, then Ms. Komorowski, pursuant to court rule, you can request that the chief judge hear that motion, and then that'll decide it. So that's how we'll proceed with regard to that. And none of that is going to result in any kind of delay, because we can still proceed with hearing the objections to that order. And Ms. Komorowski, to the extent that you want to, again, pursue disqualification, you're going to have time in the interim to pursue that, and it won't delay any matters in this case. So again, the court's denying the motion on procedural grounds. Ms. Komorowski, I will ask that you present an order under the 7-day rule or with stipulation as to form on that. And then in terms of, this was also set for a status conference today. I think our scheduling of the de novo hearing kind of addresses the status conference aspect of this, unless Ms. Dutzman-Coy, on behalf of plaintiff, was there any other scheduling matters for purposes of a status conference that you wanted to address today?
No, Judge, because I think the court was wondering essentially for the status conference, these parties were prepared to enter a judgment of divorce before we had these child-related issues come up. And so we're still obviously working through those. So I think that does handle that question about where are we in this case. So.
All right, thank you. Ms. Komorowski, anything further from your side today?
I do, Your Honor. I don't. So in the last month, I've received information from the plaintiff that she does have a 401k and that she did not disclose that prior during discovery, and she did not disclose it before we mediated property settlement. And so I would like if the court would reopen discovery, then I would like to do a subpoena for her 401k records to find out how much money we're talking about that didn't get divided.
All right, Ms. Dutzman-Coy.
Your Honor, my client forgot about this 401k because it's such a small amount of money. She forgot she even had it. When Ms. Komorowski asked me about it, I gave her information on a voluntary basis. I even offered to subpoena the records. I don't have a problem with extending discovery. I think it's sort of silly to argue over $500, but I understand the concerns of the defendant. Frankly, I would subpoena the records myself, but if Ms. Komorowski chooses to do that, that's fine.
Okay, so Ms. Komorowski, if you can, along with the order regarding the motion, if you can put in that order that discovery will be reopened for 60 days, limited to issues regarding plaintiff's 401k.
Okay, thank you, Your Honor.
All right, thank you. That's all for today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.